She should be here in another 5 minutes or so.
It's good if you stop here.
Yep. Yeah. Good morning, chiefs and delegates, elders. I don't think we can wait any longer. Grand Chief should be here any minute, but we'll begin in a way, and then he can catch up when he arrives. So, Silti Thama, Homaskuyam, Siam, Sila, Ikazwita, Haha, Tomat Loel. Just acknowledging, and just a friendly reminder for everybody that when we're bringing all of our nations of the province into a location like this, typically in Vancouver, you're acknowledging the Musqueam, Squamish, and Tsleil-Waututh, but just a friendly reminder that you're actually in Musqueam right now, so there's no need to raise the others because it's only Musqueam. So thanking them for once again allowing us to convene our Chiefs Council meeting in their home and opening the doors for that. So I'll turn it over to Elder Jewel Thomas, who will welcome us and start us off in a good way. Elder?
It's okay. I don't know how many years I've been doing this or how many years you've been coming to Musqueam. But what I do know, if you're still successful and relevant, Lord, bless this gathering, help us to open the minds, hearts, and spirits. May we receive comfort and inspiration. Bless your families at home. Bless people with chronic pain. Thank you for this day and thank you for our blessings. God bless your children. I have another short one here. Charity prayer blessing. May the Lord winds of heaven blow softly on your house. May the Great Spirit bless all who enter there. May your moccasins make happy trails in many snows, and may the rainbow always touch your shoulder.
Heichka, thank you, Elder. So chiefs and delegates, you've got an agenda before you. Are there any additions or amendments to the agenda as presented? If not, can we have a mover and seconder to accept? And just another friendly reminder, our protocol is when you want my attention, you raise your hand, I call out your microphone number, you inform the Chiefs Council who you are and who you represent, and then we go on from there. Mike 17.
Gisuk Kapineskil. Good morning, everyone. My name is Chief Joe Pierre from the community of Akam. I move the exception of the agenda as presented.
Thank you, Chief. Seconder? Seconder for the agenda? Mike 19.
Cora Anthony, proxy for Nisquallis. I second the motion.
Thank you. Any discussion? Hearing none, it is carried. So we'll begin with opening remarks from the executive, starting with Cookby at microphone 2. Mic 2.
Good morning, everyone. Welcome to the 51st UBCIC Chiefs AGA. We're very honored to be on the ancestral land of the Musqueam people and the current descendants today. And thank you for our elder providing us the wonderful prayer to start our day. As you see with the agenda, it's fairly jam-packed. We have a lot of information to share. A lot of things have been happening across Canada and in BC. And we have a lot of the different cookpies from different regions that are helping out, and they're stepping up and reporting out on the different issues, like Cookby Fred Robbins about the Big Bar rock slide that impacted our salmon traveling back to the spawning grounds. And we have legal updates, including the different cases and the BCTC new directive policy. we heard about some of it out at the AFN in our BC Chiefs Caucus. We had discussed it, and we thought there was going to be opportunity for us to discuss it before the federal government, provincial government signed it, but unfortunately, there wasn't that time allotted. And the union, we didn't have that time to be able to discuss that policy. And a lot of it was after the fact, unfortunately, and I know it'll be part of the legal updates and part of the different discussions on title and rights throughout the next few days. And also, I wanted to say, we have the information regarding, the children and family, the legislation that we're dealing with, the language legislation and the children and family that's really important to our communities and standing up our jurisdiction over children and family. There still seems to be a lot of challenges, especially around birth alerts. The province is saying they'll step back on that, but again, we still hear, the practices and the concerns on the ground that's impacting the children. And we still have to do our due diligence in around that issue. So it's going to take a while for, the work we're doing in jurisdiction to really hit home in regard to the province and the ministry, the machinery that they work in regard to, their assumed control and jurisdiction. So moving the path forward, it's really important. I know many nations are working on it, their jurisdiction. And in Spatsine on October 7th and 8th, there's a lot of the bands that are working on jurisdiction are coming together. I'm there on the 7th, but on the 8th we have our specific claims. Finally, we're getting our what an independent process looks like engagements rolling out across Canada. So October 8th, that'll be in this is specific claims one will be here in Vancouver. And I know it's really important also for the children and family on the 7th and 8th in the Spatsine. Then the province-wide implementation of the C92, the children and family one, will be here in Vancouver on the 9th and 10th. So it'll be a very busy week for many of the leadership and the ones working in children and family for sure. And we just have to keep doing, the best we can. The federal government said, this when they're going into election that, there is no funding coming out for the jurisdiction pieces many nations are working on. And we still, whatever the government that comes in, we still have to, now that it's legislation, hold their feet to the fire in regard to having the funding come out with the coordinating agreements, but we have to see what the coordinating agreements look like. We don't know what the language they're using in the coordinating agreements are yet for the nations that are, entering down that path. And also I wanted to say from the AFN, they had a climate declaration and I think for our respective nations, what does that mean to the proper title holders, to our people? We see the effects of climate change happening at all levels, and it really is, like a lot of these states are trying to tell Greta Thunberg, the young lady that went to the UN that said there's a climate crisis, and it's an emergency. A lot of the state governments are trying to say, no, she's just raising climate hysteria and discrediting her. And I'd like to say Greta was very courageous to go in front of the United Nations and say what's happening. And our Indigenous people, on our land, we're the ones that feel the effects the most. And I was thinking, well, what could we do? I was thinking, well, maybe we could write a letter to her, first of all, thanking her for raising that at the UN, and also for her work in all the youth climate action strikes that happened. There was one of the largest ones that happened here in Vancouver on Friday, I believe it was. It was like 80,000 people. I've never seen so many people come out. It took waves and waves just to get across the Cambie Bridge. I've never seen so many people all converge in Vancouver like that at the same time. So a lot of it was all led by all the youth, and I know all the speakers didn't get to speak right away, and you try discussing that with a 9-year-old who's got you in control of your itinerary. So, I was worried, with the 80,000 people, they might lose control of everything, but actually everybody was very respectful, and there were a lot of the high schools and a lot of the colleges, so many youth that came out. A lot of our own Indigenous youth were out too, so I really was happy to see that. So I just wanted to say also, I wasn't able to attend David Dennis's celebration, but our Grand Chief did, and hopefully he can make some remarks on that. And I just wanted to say it, for all the work David Dennis has done for our communities as well. It's good that we're able to share that with him, so that he knows, that him and his family, the importance of that. And the only one point I'm going to finish on, Ty, sorry I'm taking so long, is the UN declaration. We are going to have time to look at the draft. There's a sign-up sheet. See the technicians, Andrea, to sign up for it. And it's important the chiefs take a look at that. And I think there will be a reviewing scheduled. I can't even remember now the time Andrea told me. But it's important to look at what that UN declaration. We had to really push the table to say, the right holders need to have that direct look at themselves, review themselves. So it is here now, and I hope you all are able to sign up and take a look at that draft. And the gaming revenue is supposed to be coming out finally, but I was really worried with what happened, like with the rural dividend fund. The province secured that money to redirect it over to the forestry, and I was worried they would try to do that to the gaming fund, but I haven't seen any indication of that. But I'm still upset that the rural BC funds, are being directed, and a lot of proposals were in the rural BC, and a lot of our communities use that rural BC funding. So anyway, thank you for coming here today, and looking forward to the dialogue and direction from our chiefs over the next 3 days. Thank you.
All right, thank you. CM Salquan, CM the CA, my dear elders and relatives who are here this morning, happy to be here, and thank you for making the time to travel from your home communities to be here with us this week. I was just telling Cookbee Wilson that I was showing her my speaking notes for what I was going to share this morning, and a lot of it was the very same what she shared. I think she did it more articulately than I would have, though. Thank you, Cookbee. Since we last met, a lot has changed, and I think we're in an interesting time here in BC, looking at whether it's the BC gaming revenue or Bill C-92 with our children and families. There is substantial movement happening within our communities, and it's, if you're like myself at home, it's a lot of information to keep up with. And I think just there are some opportunities there for us that are coming, whether it's legislation on languages. Also, we have an election happening during this time, and encourage all of our voting members to get out and vote, and encourage your younger people to get out and vote as well. I've had some discussions with some of my younger nephews, and they have a lot of reluctance to voting, and it seems very intimidating. But I think there's data that shows that there are many impacts our First Nations communities will make on election night, so I hope everyone gets out to vote. I won't say who I'll be voting for, but thank you. But also, I think since we last met as well, there was the Big Bar landslide, and so we're the Leadership Council as well. Myself and Grand Chief had the opportunity to go and do a tour up there and to see the work that was going on prior to the salmon being able to get up on their own, and it was just a tremendous amount of work by many people who were committed to ensuring that what would be, I consider, our livelihood, because it's such a necessity that is so important to many of our communities and helps us get through our winter time. And so if you're like myself, happy to hear that they're passing through the slide area on their own now in large numbers. So we're happy to hear that, but otherwise, thank you for taking the time to be here, and I look forward to the next couple days of dialogue with you. Haichka.
Haichka Siam, Grand Chief in Mike 4.
Wai, Pisnak Seal, Esquis Asiut. I'd like to thank all of you for being here. We have a very ambitious agenda to get through in the next few days, but there's, as the executive have outlined, there's a lot of important issues in play right now. So we need to, be on top of our game here. I would like to start by thanking all those people that came out last night for David Dennis's celebration of life. As many of you know, David is suffering from life-ending liver disease, and he had some issues in regard to accessing the list for transplants. And we had to have a press conference and engage legal counsel, and in order for them to back away from that very discriminatory policy. It's been the practice of the medical community to discriminate against First Nations people on the basis that they somehow think that we represent a risk of failure, and the allocating of organs is a very controversial issue because there are so many people on the waiting list. And so when we went public with the issue, they immediately backed away from their 6-month policy. And now they're saying that there doesn't need to be any period of sobriety or anything along those lines, which is tragic because a lot of our people have died on that list that weren't able to, do the 6 months, and they were so severely ill at that point in their lives that they just didn't make it. So we're still engaged with the health system. We had a meeting with Minister Dix, and last night David was able to get some of his home community people from Hawaii together, and all of his friends and the usual suspects over the years got together down at 312 Main, where our offices are, and it was an incredible night, a very powerful night. And again, I just want to thank everybody that did come out and support David. He is going to require further support as he moves through this, this issue. So with that, I'd like to thank the executive for their comprehensive reporting out. I was pretty impressed the other day when we had 100,000 people out on the streets in regard to climate change. And what's interesting about that for myself is I don't know how many speeches I've made at rallies and marches saying we need to get thousands upon thousands upon thousands of people in the streets before governments start to take this issue seriously. And I'm really happy that during this federal election, everyone's trying to keep up with the Greens. Me too, in terms of their concerns around the climate change crisis and whatnot. So it's finally getting on the radar screen. You know, it's amazing what young people can do. We've seen back in history that it was primarily young people on university campuses that led the anti-Vietnam War movement. And young people are amazing. There was, you know, somewhat, it wasn't the protocols that we would have if we organized an event like that, but regardless of that, they got 100,000 people out, you know, which is absolutely amazing. It's the biggest march and rally that there has ever been, so there's hope. The Big Bar rock slide, the thing that bothers me about that is I think that's the beginning. Climate change, most people don't realize climate change also includes landslides. And we're going to see more and more landslides, rivers, you know, transportation routes and things of that nature as we go forward. So at any rate, I'm glad you're all here. And we, as I say, we have some important issues to deal with in the next couple of days. We have some important resolutions we need to get through, but it's really good to see all of you here. We were anticipating a lower turnout given the fact that BCAFN just had their 4-day session here about a week ago, but it's really encouraging to see the level of commitment I see in the room. So I notice we have a few new faces in the room. Incidentally, there was absolutely nothing left for breakfast back there. So I guess there's some merit for coming early. And I just about dropped my plate when I heard the name Joe Pierre. Joe Pierre Sr. was a very close friend of mine. He has since passed away, but it's good to see you here, Joe. Okay, Wai Lim Lim.
Inviting Ardith Walkham forward for an electoral announcement at microphone 5.
Good morning. So I had expected to attend this morning to run your election for president. I had open nominations on September 4th, 2019. Nomination period closed on September 18th. And at that time, I had only received one nomination. Accordingly, under the bylaws, I am here to tell you that I am declaring Grand Chief Stuart Phillip elected by acclamation to the position of your president. And also a reminder, I just was looking at Grand Chief's wife at the back. But also as a reminder that on February 27th, the next Chiefs Council, which will be here, there will be an election for a full slate of the rest of the elected positions within the Union of BC Indian Chiefs, which includes the Vice President, the Secretary Treasurer, as well as active members in the positions of Elder, Women's, and Youth Representative. So the nominations for those positions will open on January 30th and close on February 13th. And the union will be sending out those official announcements, and they'll also be available on their sites.
Thank Can my mic stay on, please? Okay. Thank you, Ardith. So just a reminder to the chiefs and delegates, we do have an honoring for the Grand Chief on our agenda for tomorrow morning. So I respectfully ask you to hold your remarks, congratulatory remarks till then. Next, we have a legal update inviting forward Chris Statnick and Ellen Sigurdsson from Mandel Pinder to come over to mic 5, please. And while they're coming up, Cookby raised the consultation piece around the province's work on the declaration. There is a sign-up sheet that's available at the front desk for you to sign up on now. What the process is going to be is that anybody that would like to be a part of that consultation on October 3rd from 11:30 to 12:30, you encourage you to sign up to the list. It's going to be in a classroom probably across the hallway here. The process is that once you sign up, you walk in, you're going to have to sign a non-disclosure agreement, an NDA, an undertaking. You might have to leave your phone at the front desk. You'll walk into the classroom. They'll distribute whatever material they have. They'll do a PowerPoint on it. You can have a discussion on it. But any material they distribute is going to be numbered, so you're going to have to give it back to them when you leave, kind of thing. So it's a pretty closed session. And there'll be another opportunity to do that at the summit meeting in a couple of weeks, and then there'll be a few more sessions after that as well. But as a part of when you take the undertaking, when you sign the NDA, you can only have dialogue with others that have signed NDAs. You can't dialogue with somebody that hasn't signed it. So it's going to be tricky. It's not our affair, it's the province's affair, and you may want to take issue with that later, but we don't have time for that right now. So turn it over to Chris and Ellen on mic 5, the legal update, and you'll find information in tab 2 of your kit. Mic 5.
Bangwinzi, good morning, everyone. I want to thank the Musqueam for once again being wonderful hosts for all your business today. And I just want to say thank you for inviting us to sit with you and present this morning on a legal update to your AGA. The update is going to focus on, as usual, recent developments since the last Chiefs Council meeting in June. And as has been spoken to, there has been a lot of developments both in the courts and in terms of legislation and policy. So we'll present a bit of an overview of those developments for you this morning, and if there is time for questions, we'll try and entertain some questions if there are questions. For those of you who don't know me, my name is Chris Statnick. I am a lawyer at Mandel Pinder. I'm also Vanta Gwichin from the community of Old Crow, Yukon. This is my colleague, Aline Sigurdsson. Many of you will also know Aline from various matters I'm sure she's assisted you with from time to time. And Aline's going to co-present on some of the developments with me this morning. So just sort of a high-level overview of what we're going to present. The last few months we've seen a lot of developments and a lot of case law around the duty to consult, as well as where consultation has failed to deliver a remedy and First Nations have sought other means. So we're going to talk a bit about some of the pipeline approvals, the exploration drilling in the Tetsan-Bini, Chilcotin territory, and recent fisheries allocations decision that came down in relation to the Squamish request for an increase in their allocation. Also going to provide a bit of an overview on the historic compensation ruling that came down from the Canada Human Rights Tribunal, where they have ordered Canada to pay the maximum allowable compensation to peoples that were victims of the discrimination under child and welfare policies. I'll also just give a very quick update on what federal legislation affecting Indigenous peoples did receive royal assent in June. And then I'm going to also just give you a brief overview of a few Crown policies that have been introduced since June.
Thanks very much, and I echo Chris's gratitude and appreciation for your welcome here and to the Musqueam people, and also congratulate the Grand Chief on his re-election. So the first item that I get to update you on, as well as the second, are about the Trans Mountain Pipeline approvals and the challenges to those processes. So the first is in the Federal Court of Appeal. So these challenges are the second round of challenges that have been brought. And you'll probably remember that in the first approval of the Trans Mountain Pipeline, the First Nations applicants, as well as the environmental organizations in the cities, were successful in having the approvals quashed. Those approvals were sent back for reconsideration to the National Energy Board and to the Crown for further consultation. After that all happened, they were reapproved. So what had to happen next was any parties that wanted to challenge those approvals again on the basis that they were unlawful for a number of reasons had to apply to the Federal Court of Appeal for leave. That means asking the court for permission under the Act to bring the challenge. So those applications were made by 12 different parties. The court made a leave ruling, meaning allowing some of the parties to proceed with the challenges, granting 6 of the parties leave to bring the challenges, and those 6 parties were 6 of the Indigenous applicants. And what happened in the leave ruling was a bit of an interesting shift in what's happened before. In other leave rulings, the court hasn't said a lot about why leave was granted or not. Here, the court made a narrow determination about what issues were going to be allowed to be argued about in the challenges, in the next round of challenges to the pipeline approvals. And in doing that said, the 6 First Nation applicants or the 6 Indigenous applicants that were allowed leave are allowed to argue about whether or not the duty to consult was properly carried out. All the other issues that had been raised, things like whether there was bias, whether the renewed environmental assessment process before the NEB was properly done, and a number of other sort of miscellaneous issues, those were not allowed to be the subject of the applications. So the court kind of made a decision that the process was both going to be expedited and that it was going to be a narrow set of questions. So presently there are 6 consolidated, so grouped together applications challenging the new Trans Mountain Pipeline approval. But at the same time, there are some motions that are going on and potential appeals about whether this narrowing process was correct. So it's possible that we could anticipate either seeing a Supreme Court of Canada case about whether that narrowing was appropriate, or challenges in other kind of forums to whether that leave decision was allowable. The 6 present applicants are proceeding on a very expedited schedule. This means that the hearing is scheduled to take place in mid-December. That means that the parties are proceeding at twice the pace of the usual sort of schedule for something of this size to get to court. This is partly because everybody knows that this needs to be resolved once and for all. It's partly because the legislation says that these things have to be dealt with quickly, but it's also because the court is imposing a very strict regimen on people to have these determined. The second update that I can provide on Trans Mountain challenges is on the provincial side. And so while there were federal approvals that had to happen, and those are being challenged in the federal court, the province of BC had to grant an environmental assessment certificate as well. Challenges to that process proceed in the BC Supreme Court. That environmental assessment certificate given by the province was challenged by Squamish Nation. And at the lower court, that was unsuccessful. So Squamish said that the duty to consult had not been carried out properly, but also that the environmental assessment certificate was inefficient or invalid as a matter of its substance. So that was unsuccessful. But on appeal, because the Federal Court of Appeal had overturned the federal approval that the province had relied on, Suquamish was successful in showing that the environmental assessment certificate was no longer sufficient to discharge their obligation to rely on a effective certificate. So it was kind of a cascading series of events where the federal court said the certificate was invalid, and the BC Court of Appeal said, well, if you didn't have a valid certificate there, you couldn't have a valid certificate here to rely on. So that matter has been sent back to the EA office to reconsider. So that gives the province an opportunity to think about what it might want to do in terms of agreeing to that environmental assessment certificate and what types of further conditions it might impose or ways of approaching that decision. In terms of the duty to consult argument, the court was still not persuaded that the duty to consult had failed to be carried out by the province. So that's where that matter is left. So I'm turning it over to Chris for the next couple.
There was another recent consultation case dealing with the Squamish Nation request for an increase in their allocation to Fraser River sockeye. The request happened a number of years ago, and there was, a process. I think most people on the Fraser River will be familiar with the policy framework the DFO has for requesting an allocation, an increase in allocation. And they went through that process, providing information to DFO to support their request for an increase. There was a bit of back and forth, largely through consultation letters. And at the end of the day, DFO decided to give a slight increase to the Squamish allocation, but certainly not to the extent that was requested. And they also included allocations other than sockeye in that decision to increase the request. Squamish Nation challenged that decision on their allocation request, arguing that the Crown had, in DFO in this case, had failed to fulfill its duty to consult with them on that allocation decision. At the lower courts, the first court, the federal court that heard this, had a bit of a confusing ruling where they said, and the conclusion was that the duty to consult wasn't even triggered in this case, because they said Squamish had put forward no evidence that this increased amount that DFO was offering them would adversely affect their rights in any way. So they were basing the lower court based their analysis on consultation on really a federal allocation and its sufficiency, a pre-existing allocation and its sufficiency, rather than starting the analysis from what the courts in Haida said you need to do, right? You need to, focus on the strength of claim. What is the right at stake here? In this case, it was the Musqueam or the Squamish FSC right. And so the lower court, the Federal Court of Appeals, had failed in this analysis to properly focus the analysis not on, is this pre-existing allocation with a slight adjustment going to affect you or not, but simply is making any decision about how much fish you should catch an impact or an impediment on your right. And of course, the Federal Court of Appeal under that analysis found it was pretty clear that any decision about how much fish you might catch is going to affect how you exercise that right. So it then went into this analysis of now that they found that the duty was triggered, was it satisfied? And here they felt, looking at the record, that the Crown failed and DFO failed to provide a process. And there were some interesting remarks from the court here in that they kind of said, back to first principles, regardless of, where on the HIDA spectrum, you are, whether it's, on the low end or the high end, the important point is that there's a meaningful process for dialogue, and we can't lose sight of that in trying to pinpoint where on the HIDA spectrum consultation might fall. And so from that sort of step back, she looked at what had actually transpired in the process and said, this clearly wasn't an interactive process. There wasn't a lot of engagement with the information that Squamish had provided. And when they made the determination to increase the allocation slightly, it wasn't really responsive to what the Squamish had requested and the information they provided. And there was no reasons provided, so they couldn't really understand how, if at all, what they had shared had been considered in the consultation process. So rather than quashing that allocation decision, the Federal Court of Appeal ordered it to go back for a fresh round of consultation. And importantly, and I think, the court gave specific advice to DFO, sort of in its obiter comments, sending them back to do this again, but saying, and I think it's an important quote, and it's in your materials there, it's important that department staff keep front of mind that they are effectively caretakers, managing a resource for, among others, a group or groups who claim a constitutionally protected right to access that resource. That concept should infuse the consultation process. I think that's a very important point, and if I was at any discussion with DFO, I would be pointing them to this advice from the Federal Court of Appeal, because I think it really does get to a lot of the frustrations that many feel in sort of fisheries discussions and in the consultation processes that are around allocation decisions and other management decisions. This is clearly, they also went the step further in pointing to the actual allocation framework of DFO and saying, as a policy, this is not a process that is conducive to meaningful consultation. So again, an important decision on how the Crown should be approaching these consultations. The next update is around the ongoing legal saga with the Chilcotin Nation trying to protect Tetsan Bini from the proposed Prosperity Mine, now new Prosperity Mine, as it has evolved over the years. You may recall at the last update, for those of you who were here in June, I had the unfortunate news to provide updates on the unsuccessful attempts of the Chilcotin to try and prevent essentially what was then imminent exploratory drilling in the Tetsan Bini area without their consent. And they had brought a number of challenges based on duty to consult grounds, and they were ultimately unsuccessful, with the BC Court of Appeal finding that consultation had been reasonable on the permitting of the exploratory drilling, and the Supreme Court of Canada on application for leave from the Chilcotin had denied leave. So there we saw kind of a failure, I would say, of the duty to consult as a process to really address which was a fairly serious threat to Chilcotin rights. And so as I guess a legal strategy, they went to, I heard someone use the analogy of, using heavier tools when the duty to consult fails. And so what they did is they filed an underlying action seeking a declaration of title and rights and infringements to those rights in the Tetsan Bini area. And as after filing that action, I immediately took the step of seeking an interlocutory injunction. And what that means is an injunction that would stop the company from conducting its exploration work until a full trial on these issues of infringement could be heard and determined by the courts. The company had also brought a companion application for an injunction at the same time, basically arguing the opposite, arguing for the court to impose an injunction that would have restrained the Chilcotin from preventing or any way impeding that exploratory drilling. The court ended up siding with the Chilcotin and issuing them their injunction, effectively prohibiting the company from conducting that exploration drilling until this trial can be conducted and heard. It's unclear what this means for the company whose certificate has a requirement for them to, I think, have substantial completion of their mine by 2020. And of course, they still lack even federal approval for the project. So they have many issues in front of them if they want to continue to pursue this prosperity mine proposal. I think the important, from the legal perspective in the injunction tests, the court found that this question of determining whether an infringement would occur or not was a serious issue, and that outweighed sort of the considerations that the company brought forward in what they call the balance of convenience analysis. This is an example where this legal strategy worked. There was an example around the Site C dam where basically a very similar strategy was employed, trying to seek, after consultation arguments and judicial review processes really failed to get at the questions they wanted, and the court directed them to this kind of filing a civil claim process. They had tried to seek an interlocutory injunction and were unsuccessful. So the Chilcotin example, maybe there is something instructive, but I think at the end of the day, it's really going to depend on the circumstances and the nature of the rights at stake. I'm also just going to speak briefly. I know there's going to be probably more discussion this week around just child welfare issues provincially and at a federal level, but there is quite a historic ruling from the Canada Human Rights Tribunal that, if you recall, back in 2016, following the First Nations Caring Society of Canada's human rights complaint that took over a decade to be determined, finally got the ruling that yes, there was discrimination and it was ongoing in the provision of child and family services. The tribunal remained seized of the matter, and there was a number of issues it remained seized to monitor and address. And one of those issues was compensation. Under the Canada Human Rights Act, anyone who's been discriminated against is eligible for compensation of $20,000, and you're also eligible for up to an additional $20,000, so maximum $40,000, if that discrimination was found to be willful and reckless. And so the tribunal seized of this matter issued its ruling, finding not only that yes, discrimination did occur and evidence was on the record about discrimination, but that it was willful and reckless. They found Canada had made decisions even after it was aware that its policies were discriminatory, that were largely based on financial considerations and not on the human rights of First Nations children and families. So quite a historic ruling. In terms of how that compensation process is going to unfold or will unfold, or whether any of Canada intends to appeal, that is still, I believe, all to be seen. The tribunal has ordered the parties to come back and basically report back on December 10th of how they plan to distribute compensation, assuming the decision is respected and upheld. In your package in the legal update on here, I did link to a helpful summary developed by the First Nations Caring Society of the specific compensation orders and the various sort of criteria for eligibility. It basically goes back to 2006, January 2006, and ongoing. So, a child removed today because of these ongoing discriminatory policies would be eligible for that compensation.
I now get to update you on a couple of upcoming decisions, or hearings rather. The first is in the case of Gamlakyelt and British Columbia, which is a case brought by the Gitnao hereditary chiefs regarding a failure to consult in relation to two decisions around moose harvesting, an annual management plan and a total allowable harvest. And these two decisions were challenged on the basis that the province had not consulted with the Gitnao. In the course of the judicial review, one of the arguments that was made was that in relation to one of the decisions in particular, consultation couldn't be carried out because to do so would interfere with provisions of the Nisga'a Treaty. And the area in question is an area where there's a significant amount of overlap between the interests of the Gitnao and the interests of the Nisga'a. And so what the court did in the BC Supreme Court, which is the decision that's under appeal, is the court said if there's a situation where carrying out the duty to consult with a group that has a quote-unquote asserted right would interfere with a right that's held by a treaty nation, that's a confirmed or a finalized right, the treaty right will prevail. So the appeal is about, in part, whether that creation of a precedence or a hierarchy between those two forms of Section 35 rights is allowable. And the UBCIC is intervening in that case to say that that structure, that understanding of how to treat different forms of Section 35 rights is not consistent with constitutional interpretation. It's not consistent with Aboriginal rights being inherent and existing absent any recognition by the Crown or by the court, and that it's inconsistent with how we treat other forms of constitutional rights. UBCIC is also arguing that it undermines basically the spirit and the intent of the Haida Nation duty to consult framework. So this case, again, fits into sort of the theme that Chris was talking about, which is that a lot of the issues before the courts right now are about how does the duty to consult get engaged? What are the contours of that duty? What does it mean to carry it out properly? What's the amount of leeway that the Crown has? And how do those interests sort of intersect? That appeal is happening in January 28th to 30th, and two other First Nations have been granted intervenor status, the Nakaslii and Lax Kw'alaams, and it's expected that that will take 3 days to argue. The other pending matter that I get to report on is there's a leave to the Supreme Court of Canada, a leave to appeal application before the Supreme Court of Canada that's been brought by Lac Seul, which is a Treaty 3 nation. And Lac Seul, in the early part of the 20th century, had a huge portion of their reserve flooded for a major hydroelectric storage project. And it was done, so a fifth of their reserve was taken up with this flooding and has never been recovered or replaced. And it was done without any negotiation of a release of those lands, and it was done without any form of expropriation. So Lac Seul brought a claim, having negotiated in specific claims for some time, but that process ended, brought a claim to the federal court and was successful in showing that that Canada had breached its fiduciary duties to Lac Seul. The problem was that has resulted is in terms of the compensation that Lac Seul was given. So the court decided that it should compensate Lac Seul by saying, well, at some point the land was going to be flooded because this hydroelectric project was going to happen anyway. So what we'll do is we'll think about putting the community back in the position they would have been if the breaches hadn't happened. And how we're going to think about that is will decide what would expropriation actually have looked like and give them compensation as though it had been expropriated. So the problem with that, and this was confirmed by the Federal Court of Appeal, who agreed essentially with the court below, the problem with that is that then the First Nation is being compensated for the not having been expropriated. It's not being compensated for losing the highest and best use of the land over the last century. So Laxell is trying to go to the Supreme Court of Canada to argue that this approach to compensation, where you basically reach back in time and retell a story that perpetuates the disadvantage of that community, is not consistent with reconciliation, it's not an equitable remedy, and doesn't actually put them back in the position they would have been if their rights hadn't been breached. So that argument is before the Supreme Court of Canada. They'll hear from the Crown on whether it should be granted leave, and it will be decided on whether they get leave over the next probably 6 or 9 months or so. And then we'll be able to report back on whether they are successful.
Just a quick overview. I'm not going to go in much detail at all into this, but I wanted to just put up there and make you aware of the various pieces of federal legislation that did receive royal assent all on the same day, June 21st of this year. So we have the new Indigenous Languages Act, Bill C-91 as it was, the First Nations, Inuit, Métis Children, Youth and Families Act, Bill C-92, Bill C-69, which is the new Impact Assessment Navigable Protection Act, Business, an act to amend the Fisheries Act, Bill C-68, that was restoring sort of the habitat protection provisions that had been previously gutted in amendments. There's, of course, new innovations in that act as well that I'm sure you might hear about a little more later in the fisheries discussions on your agenda. Bill C-48, which is the tanker ban on the North Coast, that did finally pass, sort of after years of advocacy of those coastal First Nations. An act to amend the Corrections and Conditional Release Act. I highlighted this because it deals with the solitary confinement provisions under applicable to federal inmates, and it's intended at least to remedy the findings that the previous approach to solitary confinement or administrative segregation under federal law was discriminatory and proportionately so against Indigenous inmates who are disproportionately placed into solitary confinement under the previous regime. And then, of course, Bill C-97, which is the budget bill, passed, and I just flagged this because within that was the new legislation separating the Department of Indigenous Services Canada and CIRNA, Crown Indigenous Relations. So it's worth a look. There's in the new legislation establishing these two separate departments, there is, information about exactly what the role of the minister is in administering that act. So I think it's helpful just to think about and look at and see how those two government departments are reimagining themselves. Policy announcements. I'm only going to speak briefly to this. We did provide an update, the last update, and my colleague, Chloe Ostrov, I understand is on the agenda tomorrow afternoon, and will be speaking more in depth about this policy. I know it's a subject of ongoing discussion amongst the union here. But the policy has been now publicly announced and released by the principals of the BC Treaty process, BC Canada and the Summit. And again, this is a policy framework that's intended to guide the negotiations of treaties as well as other agreements and constructive arrangements with those Indigenous groups who are participating in the BC treaty process. We have, in previous reports, identified some concerns with the draft policy as it was being developed, and I think Chloe's going to report on this tomorrow. You know, some of those concerns have been somewhat addressed with drafting changes that now appear in the final draft, just in terms of who does this policy, who's it intended to apply to, and bringing more clarity to that, while others remain, you know, without being addressed. So the one main concern being overlap or shared territory issues. It is flagged in the policy as something for discussion, but later down the road. Another policy I wanted to place on people's radar that was announced was Canada's collaborative self-government fiscal policy. This was announced by CERNA, Minister Bennett, here in Vancouver about a month ago, I believe. And this is a new policy framework that's intended to apply to those Indigenous governments across Canada who have comprehensive self-government arrangements. So either a self-government agreement that's comprehensive in nature, or self-government provisions in a modern treaty that are comprehensive in nature. The policy framework is intended to guide how the federal government approaches the negotiation of fiscal arrangements. So, you know, essentially the policy deals with what is the fiscal relationship with those under a self-government agreement. There had previously only been, well, for many years there had been no policy on this at all. And then it was actually one of the last acts of the Harper government who passed the Valcour policy for self-government policy. This effectively repeals and replaces that Valcour policy. It was developed or co-developed with the participation of all those Indigenous governments who do have an existing self-government. Well, almost all. Some opted not to participate in the process. Essentially, it provides a way of measuring estimated costs of delivering your self-government responsibilities in a way that is intended to be more objective and transparent. So you actually know where federal negotiators are getting their mandates from on the fiscal side of things. I also wanted to flag, and this may come up in the fisheries discussion as well, DFO released the DFO Coast Guard Reconciliation Strategy, and it describes Canada's approach to how it plans to advance reconciliation in fisheries, oceans, aquatic habitat, and marine waterways. The strategy is accompanied by an action plan, and that action plan is intended to be responsive to a number of recommendations that were recently made as a result of an Indigenous-led DFO program review. And so you can look at the responses to those recommendations that are in the action plan. Of course, I flipped, did a Control F for priority. You know, that was one of the strong recommendations from the Indigenous-led program review is you need to correct your application of priority, particularly in these circumstances now where we're more and more in a position where no one is able to meet their FSC needs on stocks. And that means closing marine and recreational fisheries in these times. In the strategy, it identifies the issue of priority as something that continues to be under review and set for in the long term to being addressed. And I will close there, and that's what we have in an over and turn to the chair if there's any time for questions at this time.
Thank you, Chris. Elaine, there is a couple of minutes for any questions or comments chiefs or delegates may have, keeping in mind that some of this comes up later in the agenda as well. Microphone 10.
Chief Wayne Christian. I just want to acknowledge the Musqueam people, their ancestors, and the present-day descendants for the work we're doing here today. I guess around the legal stuff, and we know that there's impending provincial legislation on UNDRIP, And I'm wondering if the lawyers such as the Mandel Pinder and that are looking at what does that mean on the ground for our communities? Because the implementation of UNDRIP in provincial law and the harmonization of it's going to have an impact. But what's being done to sort of prepare the communities for that onslaught of, first the negative, because there'll be a lot of, sort of, how do you put this, the rednecks will rise in this process because of the legal implications, the business side, et cetera. And our chiefs need to be, the chiefs need to be well armed with what this actually means. So is the union going to be doing any work actually and sort of doing some preparatory sessions, or, because as I understand it's going to go to the fall sitting in the legislature and it's going to have an impact. But I have seen nothing that's gone out and nothing's gone to the communities, nothing's come to the chiefs to say that this is what you need to pay attention to. And so I think that it's really important because it's setting the stage for a fundamental shift in how British Columbia, the province, actually views the inherent rights of our people, the title and rights of the Indigenous nations of British Columbia. It's a fundamental shift. So it's going to have an impact. So I wonder again, as Mandel Pinder looking at that, and maybe with other sort of legal firms starting to look at a kind of a response so the chiefs have some ammunition. Because we're going to be hit with, on the ground with the communities or the businesses, just the local governments, et cetera, et cetera. And we need to be able to respond in such a way that it is really clear that what this is certainty. Certainty for us, and certainty for the province, certainty for the business community, certainty for the citizens of British Columbia. So I think something needs to happen in this area, because I know this legislation, we talked about the BCFN is being proposed. We haven't seen it. We have the presentation. It's on the agenda later. But I think the lawyers in British Columbia, especially those that work with the Indigenous nations, need to prepare, for this, because it's a reality. It's going to happen. And again, it's the chiefs that are going to bear the brunt of the pressure from the public on this issue, and also from our members on this issue. So we need some information, we need some facts, we need to be able to respond to this in a coherent way. So I'm just asking, is that something that Mandel Pinder is looking at? Cookstram?
Cookstram, Cookby? Like 5?
So I can only speak for myself personally. I haven't been asked specifically yet to kind of put my mind towards the pending legislation. I haven't been involved in that process of reviewing and developing it. So I think my understanding of the proposed legislation at this stage is probably similar to yours. But I think there's just generally, without having to review what legislation might say, and putting my mind towards what actual UNDRIP implementation means on the ground. I hear you, and I think our work, this provincial legislation is simply, in my view, another tool to help you guys get to where you've always been trying to go. And the task is really similar to what it's been in preparing yourselves now with additional tools at your disposal of what is your vision for self-determination, and how do you see that playing out in accordance with your own governance structures and your own legal traditions? Because that's ultimately where the transformation is going to happen, and what that looks like is going to be different for each one of your nations who have widely different circumstances, different territories, resources, different challenges, issues, priorities, different laws, different cultures. And so, it continues to be that work of building what you want to implement, and being prepared for that moment where tools open up the door a little more to advance those visions. So just at a very high level, that's where I'm at. And so, I think with individual clients, some in these rooms, yes, that work is ongoing in different areas. Sometimes it's not comprehensive, sometimes it's limited, to different initiatives, whether it's, water or wildlife. But this work of, I think, of helping define a comprehensive vision of what does UNDRIP mean to you? What is, how do you exercise free, prior, informed consent, for example, within your own traditions? Those are the type of work that I think could be really beneficial in helping you prepare for, whatever provincial legislation might say.
And Cookbee, from the union perspective, the staff are working on a session specifically for this discussion. So as soon as possible, a save the date notice will go out, and we'll have time dedicated for this. But I'm going to kind of cut off question or discussion there, because we have lots of time on day 3 to further this. We have Mary Ellen Turpel-Lafond heard your question, Cookbee, and I'm sure she'll speak to it in her presentation on day 3 as well. So we are going to move on. Thank you, Chris. Thank you, Aline. Going on to specific claims, inviting Jody forward, near Cookbee if possible, for a specific claims update, starting at mic 2. We're going to stay there? Come out this way.
Stay here? You're going to stay here or move over there?
Whatever.
Dalton? Lim Chaeltach, are you here? Chief Dalton Silver, could you come forward, please?
Is there here? Oh, it's making this way. Okay, Cook's Jam, Chief Judy Wilson, as the co-chair, Chief Dalton Silver makes his way over here. We just will, it's our first time we got bumped up in the agenda, so we're ecstatic about it. I just wanted to say for the research funding, the 2019 federal budget was $40 million for over 5 years for claims research and development. You probably can see it on the PowerPoint. Jody, are you doing the PowerPoint? Okay. And so the specific claims branch will have to justify the increase to Treasury Board. CRUs will have to show the results. UBCI submitted a supplemental funding application for 2019-20 and the multi-year application for 5 years following. However, the increase in funding does not include funding for First Nations to take their claims to the tribunal, and the tribunal chair said it was very woeful. Like, it's just like, how do you prepare for that? And I'm going to just turn the technical part over to Jody to go through it quickly. There's a few slides here.
Thank you, Cookbee, and I'd like to thank our hosts and the cooks, as usual, for a great meal, and acknowledge that we are on the unceded territory of the Musqueam Nation. Thank you so much. Okay, so the BC Specific Claims Working Group has worked on, over the last year, just over a year, we've worked on a number of studies and reports to highlight and advocate for some of the issues that nations are experiencing with respect to resolving their claims. So two of these reports have to do with the 3-year deadline that Canada has to assess the claims that are submitted. Canada has a legislated obligation to review these claims within 3 years of their being filed. Our original report was in November of 2018. And we found that in the vast majority of cases, Canada had been missing its 3-year deadlines for anywhere from 1 month to well over a year. We made a number of recommendations, and we didn't hear back from Canada on this at all. The other major finding was that Canada hadn't been communicating at all with Indigenous nations about the reviews being late. Even when First Nations were contacting Canada and asking. So the one outcome of that appears to be that Canada sent some form letters after that saying, sorry, your claim is late, but they didn't provide any information about why it was late, why they were late, and didn't provide any sense of what any new timelines would be. So we did another study a few months later, some months later, to find out if the issue was ongoing or if Canada had addressed it. And one of the things that that spurned us, I guess, to do this. That's the wrong word. Anyways, that got us to do this study was that at the 2019 joint gathering, the specific claims branch negotiations director, Natalie Neville, reported that Canada had a plan in place to deal with this backlog. And we asked about it. We asked for a copy of that plan, and no copy was produced or response was received. So we did another study to see if Canada had somehow put in place this invisible plan or had addressed the 3-year deadline. And what we found was the problem was actually increasing and getting worse. And while some claims that were under the original study, the deadline had received their reviews, the number of claims that where the deadline passed had increased. So in that, we made a number of other recommendations, and once again, we haven't heard back from Canada on this. We did another study, and this one was interesting because it was at the request of the specific claims branch, the then Director General Stephen Gagnon, and he wanted us to look at Canada's conduct at the specific claims tribunal. And this is because First Nations had consistently and increasingly reported that Canada was behaving badly at the tribunal. So we did a survey. We did it just among BC First Nations originally, and indeed discovered through the survey that Canada's conduct at the tribunal was unnecessarily adversarial, that there was a lack of resources and a perception that resources weren't equal for First Nations, and that there were lengthy delays caused by certain behaviors that Canada was exhibiting that created uncertainty and increased costs for First Nations. So we concluded that study with about 6 discussion questions, and remembering that Canada's the one that actually wanted the study done, we expected that Canada would engage with the BC Specific Claims Working Group or reach out to First Nations directly to talk about these issues, and we received no response to that as well. So we completed a follow-up report and did the survey a little more broadly. We did it across Canada instead of in just BC, and all of the results from across Canada confirmed the findings that we made in BC. And then the BC Specific Claims Working Group had a quick impromptu meeting with the Director General of Specific Claims Branch and asked him why hadn't he responded to any of this. So on September 12th, we actually received a letter from him indicating his willingness to meet and discuss the issue. However, it is election time, so that meeting can't happen until after the election. And then we are also, through gathering all this data and just meeting and talking with people, we're also learning of a number of emerging issues or items, concerns in negotiations. So this follows public reporting on Canada, but from Canada, that the number of negotiation tables has increased dramatically, which on the surface is definitely true. But what we're hearing are a number of related items that may be concerning, so we wanted to try and find out a bit more information. So the first of these has to do with negotiation funding. And as you know, negotiation funding is loan funding. When funding for comprehensive claims was converted to grant or contribution funding and loans were forgiven, there was an announcement that the same would happen for specific claims, and this didn't happen. And finally, we heard that this wasn't going to happen, at least in the foreseeable future. But there was a lot of mixed messages around that, and the lack of commitment around that is concerning. But at the same time, and maybe to offset the bad news, what they did do was promise to provide, at one point they said up to $75,000 in upfront pre-negotiation funding, and open up tables that originally were closed by their rejection letters. So we asked, how was that being communicated to the nations? They didn't have a communication strategy. They said they were going to inform their negotiators. When nations at the table asked Canada's negotiators, many didn't know about it. So we talked to the branch and asked for follow-up. They then clarified that it wasn't 75,000, it was up to 15,000. They also clarified that this comes off the total loan amount and that the total loan amount itself isn't going to be increased. It does open up the possibility for, having pre-meetings and talking with your lawyers and working out a negotiation plan, but there's a lot of information about that that isn't communicated still. So that we're not sure. We're just sort of hearing things bit by bit about this. So one of the things that we wanted to do, and that's been successful for us in the past when we start hearing sort of rumors, is that we figure out a way to ask you directly what's happening. So what we did was we produced a survey, and it just was launched last week. And it's really a survey for any community that's involved in specific claims negotiations and research, or who has a lawyer or a claims research unit like UBCIC Research. There are several. Some questions about what's going on with their claims and trying to understand really what's happening at negotiations, but they're broad enough questions that they wouldn't violate any confidentiality about negotiations too. So that survey is launched online. It's lengthy. It takes about a half an hour to do. And we've also printed off about 20 copies. So we really encourage you, if you're willing, to fill out the survey or direct your legal counsel to fill out the survey, or your claims research unit to fill out the survey, and just help us really gather that information so we're understanding it correctly rather than sort of relying on the rumors of it. And at the same time, we're really concerned about the way that Canada reports publicly on specific claims and communicates about specific claims. One of the main tools that Canada uses is an online specific claims database, and we've discovered through the years that that database is used by Canada to make a lot of misleading statements about the success of specific claims. One of them that we've noticed recently is a lot of claims are listed as in negotiations or in active negotiations on the specific claims database, online database. And we've talked to some individual nations and they've said, well, wait, we haven't sat down with Canada. We don't have a work plan. We haven't been funded. Why is this listed as in negotiations? So again, we're hoping to talk to you directly about this. So what we've done is printed off out front all of the claims that Canada lists as inactive negotiations in BC. And then we have a few questions that we just wanted to sit down and ask you about that to see if they're actually in negotiations. So if you do have claims in active negotiations, it would be so great if you could just visit the front desk. We'll look it up for you. You can see how it's being publicly reported, and if you would be willing to answer a couple of questions about that, we'll try and get a sense of if it's being reported accurately. And then I think the next, I'll turn it over to Cookpee.
So in regard to the work on calling for an independent specific claims process, the Joint Technical Working Group is finally moving forward with that. There was some funding that received from to the AFN to hold regional engagement sessions. There's about 1.5 million for it. The first ones in BC will be October 8th here in Vancouver, and then Fort St. John, October 9th. In addition, at the National Claims Research Workshop at Six Nations Territory, later in October, on October 23rd, another session will be held. So there's 3 opportunities for our BC chiefs and their technicians to get out. However, we noticed on the registration form there was ambiguity in regards to if your technicians would be paid for. I know Dalton and I jumped right on it, and Jody fixed it. We sent a letter or email or a text to National Chief and to Will David at AFN, so it is fixed now. So registration forms are clear that your technicians will be paid for to attend, because it wasn't very clear. And also, you know, that to encourage the people to enroll, because we've been waiting for this for a long time about the independent claims process. We really need people to get out there and, to those engagement sessions so that we can have a real strong report. They'll be structured according to fairness, independence, impartiality, openness, and transparency, and alignment with the implementation of the UN Declaration. And also the BC Specific Claims Working Group, we worked with Ardith Welcome of Cedar and Sage Law to produce a video on our laws arise from the lands. That'll be shown at all the sessions, so that's a debut video, and I watched part of it, and it really is a strong message in regard to BC, what we're doing, but also to encourage this independent claims process. Just to pick up on what Jody was talking about with the UBC online survey, very critical. We did this a few years ago when the AFN was rolling out some other sessions. We did our own work here in BC, and we came up with a really strong report, and we need to continue to do that. The data that we collect produces the evidence-based reports that challenges statements of Canada, and we really need that to be successful. So again, just underscoring, to take the online survey. And then the mini survey on negotiation status, I think, how long is that one, 5 minutes? 5 minutes. 5 minutes tops, and if it's longer, Jody's gonna buy lunch. No. So anyway, I didn't say that. So I look to Dalton for some closing remarks.
Thanks. I want to acknowledge the Musqueams for opening their doors again for the important work, and congratulate Asiut on his acclamation as president again. I really want to commend the staff at UBCIC for the great work they do on the research with very limited funding. I think you've heard what the ladies are saying. It's not a level playing field when you're negotiating with the government on these claims, and the screening process is done by the government themselves, those who you're negotiating with. It's like, I was thinking of, it's like akin to playing in a game where the referee is actually a member of the other team. And that's something we really need to change. I've said it before, and I'll say it again, that, I've said to federal officials last year at Halifax that, especially here in BC, where there are very, very few agreements with any form of government, whether you look at it through Indigenous law, through British common law, or through international law, everybody knows whose land it is. And yet they put us through these processes with very limited funding for our researchers or our negotiators to try and prove that it is indeed our land, when they all know whose land it is to begin with. So I think, we thought maybe there would be some improvements in the funding and in the negotiations through the election last time. The Conservative government really cut the funding down almost to the point of shutting down research units across the country that are actively researching the claims of our people. But we thought that funding would be coming back fairly soon with the Liberal government, but it's been a long time coming. They have restored some funding, but not to the point of being adequate for our research units. And I think the sessions that are coming up, I encourage anyone to attend, or get your technicians out, or anyone else out there, because I think we need to push the land claims issue. We need to get everyone together to make a strong push on the claims issue, and that it doesn't seem the new government is hearing us, and there's another government coming in soon, or maybe the same, but either way, it's a hard battle to go against. And I want to say too that the tribunal was set up, we thought, to make it a fairer process. The government put a lot of money. They haven't even disclosed how much money they've put into the tribunal, and then the tribunal makes a decision. In all fairness, it seems the decisions go more in the favor of the Indigenous peoples, and then the government turns around with their lawyers and they appeal the decision of the tribunal. So it's like they've set up this process, who knows how much money they spend on it, and then they spend a lot more money fighting their own decisions. It's just backwards. And I talked with an old chief years ago. I said, I'm trying to find logic in the politics of the federal and provincial government. He said, don't look too hard. You'll waste your time. There's no real logic there. But I think we all need to push for a fair process. It's been a long time coming, and I do want to commend the work of my colleagues here in pushing this issue forward. There was also a bit of a success, I think. I want to commend some of the communities upriver. 7 communities actually settled a claim, and I think that's encouraging in that our respective communities, where there's a claim that includes one or more of the communities, I encourage people to do what you can to get together, strengthen that claim, and I think they received a pretty healthy settlement in it. It took the efforts of 7 communities to get together and actually commit to working together on that. So with that, thank you.
Thank you. Just before opening up to questions and comments, just I was remiss in announcing at the onset this morning that your 51st Annual General Assembly is being webcast. So keep in mind our citizens back home are able to dial in and listen in on the dialogue. And should it come to a time in the agenda where you feel it more confident that it not be webcast in terms of strategy development, please signal that to me at the time. So with that, any questions or comments regarding specific claims? Seeing none? Any? Cook? Oh, Cookby's promising iPads for the surveys. And lunch from Jody. No, I say that teasingly. There aren't any prizes. Any concluding remarks, Cookby or Jody?
Just
Mike, too?
we've set up. We have registration forms and surveys at the front, so we'll help you fill it out and do what needs to be done.
That's basically what I was going to say. Okay, we're done.
Okay, thank you to the panel. And we're waiting for one guest for the next panel, so let's take a 15-minute break. It's 10:52 right now. We'll reconvene at 11:05, and we'll be reconvening into the justice update. So let's take a 13-minute break. So our next agenda item was with respect to justice, inviting forward to my right David Eby, Closselton and Hyathet, Douglas White and Boyd Peters. Would you come forward, please?
Well, you guys should wait for me.
David Eby, Closselton and Hyathet, would you come forward, please?
She came and said hello. Yeah, thank you.
There's 3 here.
Yep. Well, how many do we have?
Congratulations. Nobody run against you. Is it?
Oh, we. Yep. And you're starting, Dave? Yes. Good. Okay, so given we've got 30 minutes on this topic, we'll begin with microphone number 5.
Good morning, everyone. David Eby, I'm the Attorney General for British Columbia. It's a great honor to be joining you here today, and I'd like to begin by recognizing we're on the territory of the Musqueam people and thank the Musqueam for the opportunity to be here today. And thank you to the UBCIC as well for the chance to be here. I'm a longtime collaborator before politics and hopefully continuing well into politics with the Union of BC Indian Chiefs on especially issues affecting urban Indigenous people. So it's a great honor to be here presenting to you in this role today. Thank you very much for that. The big priority in my office as Attorney General is obviously addressing overrepresentation of Indigenous people in the justice system. And one of the things that was surprising to me on coming into the role was that the province had never had a justice strategy that was drafted in partnership with Indigenous people. It was always what was described to me as Indigenous informed. So the drafts would go for review and feedback, as I understand it. I wasn't there. To Indigenous people, but in terms of coming up with how to address the issue, the strategies were not co-drafted in partnership with Indigenous people. Just the opposite, they were written by the province for Indigenous people. And so the exciting work that we've been doing with the First Nations Justice Council started with signing an MOU with them and providing them with funding so that they were able to participate as partners in drafting an Indigenous justice strategy for the province that is actually drafted in partnership between Indigenous people and the province and reflects our commitment to work together to implement it. A lot of work has been done to date on it. It's approaching, as I understand it, it's approaching a draft that is quite detailed, and I understand there'll be a presentation from Doug White from the Justice Council following after me about some of the details of the work that they've been doing. But the focus of the draft, unsurprisingly, is on reconciliation, decreasing the number of Indigenous people in contact with the justice system, improving the experience of Indigenous people who are in the justice system. So understanding that we've got a long way to go on that front, addressing violence against Indigenous people, especially women and girls, engaging with Indigenous communities and organizations in a respectful and culturally appropriate manner, improving access to justice services for Indigenous people, and finally, designing services that provide Indigenous people with culturally relevant, flexible, and user-focused processes. All of this really, to my mind, is about making sure that justice services make sense to Indigenous people in the sense that there's a connection between where we want to get to, which is reducing overrepresentation and ensuring that justice is actually a justice system for Indigenous people. A lot of this work was done last spring, and throughout the summer there was a roadshow where the Justice Council held 4 regional engagement sessions talking with leaders in Indigenous communities in the justice system and community members about what the justice strategy should include and what it should look like, what transformative change looks like. So there's been a lot of amazing work going on with that, and government is fully supportive of this process, as well as implementation of the plan. And there are some core components that are so critical to it that work has already started in terms of moving forward on some of those strategies. You will also, I understand, have heard about the work that's been happening on the UNDRIP legislation, and I also understand that you have an opportunity to sign an NDA to review drafts and to understand a little better about what's going ahead. As part of my job as Attorney General, I get a mandate letter from the Premier, which included requiring me to work in my office and consistently with the call of the UN Declaration of the Rights of Indigenous People, as well as the Truth and Reconciliation Commission calls to action. It's very exciting. This legislation has been put together in partnership with Indigenous people. I hope, will create a predictable path forward for everyone, which means good jobs and opportunities, and also means upholding Indigenous rights and protecting the environment. And there's been a lot of excellent work on that, and I understand you're going to be hearing some more about that on Thursday. Finally, the legislation requires that government, proposes to require that government bring our laws into alignment with the UN Declaration. It's a very important and a very significant and a very big piece of work, but we're making and expect to continue to make real progress on that. And hopefully this fall, if everything goes according to plan, that legislation will be introduced and will pass and will be on a new path forward with Indigenous people in Canada and consistent with international human rights obligations that our government accepts and embraces. So thank you very much for the opportunity. I'm going to keep my remarks relatively short because there's no such thing as a bad short speech. And I'll invite any questions that you may have for me about government priorities, and I'll do my best to answer. And if not, I have a staff member here who will take notes, and we'll have to get your contact information, then we'll follow back up with you. Thanks very much.
Thanks, David. We'll go to questions after we hear from the Justice Council. So we'll go to Mike 4. Mike 4.
Asiam Nasiaya. Ain't pek colossal tintanis the namoch, ait na squalawan, quanas heitsepka, masquim stimoch, heitsepka siam stimoch. Good morning, everyone. It's an honor to be here at the Union. I want to first acknowledge the leadership around the room. Particularly Grand Chief Stuart Phillip and his recent acclamation. Share congratulations. The work of this table has been obviously seminal in creating space for the proper implementation of our self-determination rights. The work of this table has been very important in the development of creating the politics and the space for the creation of the United Nations Declaration of the Rights of Indigenous Peoples, and also for the way that it's being implemented going forward. The work around this room in terms of criminal justice reform and the crisis in children and families has always been top of the agenda. The Justice Council was formed a number of years ago with a mandate to address that work, and as we've been reporting over the past couple of years, we've been doing work with the provincial government to reform the criminal justice system through the creation of a new Indigenous justice strategy. So we're here today to give a quick report. Myself, Doug White, Kwalasalton, Rosalie Yazzie is the appointee from the BC AFN. Boyd Peters is with us, the appointee from the Union of BC Indian Chiefs. And our new Executive Director, Gayleen Askland, is here. So I'm going to pass this over to Rosalie to go through a presentation. Mainly want to hear feedback and commentary from the floor, so we're going to keep this as brief as we can.
Thank you, Doug. I'm Rosalie Yazzie. I'm a member of the First Nations Justice Council. Congratulations, SU, on your 8th term as president of the UBCIC, and thank you to the union for having time on the agenda for this presentation. This is a similar presentation that was presented at the BC Assembly of First Nations meeting about a week ago, actually in this very room. So I'll be taking you through this presentation, which outlines at a high level in terms of some of the activities activities that we've been carrying out over the last number of months in relation to the Indigenous Justice Strategy, as well as the work of the First Nations Justice Council. So here we have just a little bit of context, the various appointments. The Union of BC Indian Chiefs is one of the 3 organizations that the First Nations Justice Council reports to. And then there's also within the 5 members of the council, there are different leads or portfolios that are held by each member. For instance, Doug White is the lead on Gladue in criminal justice. Boyd Peters, which is your UBCIC representative, leads on policing and corrections. Myself, I lead on First Nations Court. Tracy Downey leads on Indigenous Justice Centers and Women in Justice, as well as Anita McPhee, who's the lead on Children and Families in Justice, as well as Health and Justice. As well, we also work quite a bit with Colleen Spear, who's a former Justice Council member, who's also jointly appointed Executive Director of the Indigenous Justice Strategy, located in the Justice Services branch of the Ministry of the Attorney General and the FNJC. So in September 27, the Justice Council and the Ministries of the AG and the Public Safety and Solicitor General entered into an MOU, and this was to jointly develop an Indigenous justice strategy. This represents a historic milestone in the justice system, and our goal is to have a First Nations justice strategy drafted by the end of September 2019. Given that it's October 1st, a little bit of an update. It is well underway, so that draft will be coming to you in the next few weeks as we plan to roll it out with the ministries involved that we're working with. In terms of the Indigenous justice strategies, as was mentioned before, there was a provincial forum that was held earlier this year in April of 2019 here in Richmond, as well as 4 regional engagement sessions that took place across the province. Some of the immediate priorities that were identified through those lines of dialogue include the Indigenous justice centers, diversion alternatives to courts, reduction of administration of justice charges, First Nations courts expansion, Gladue in the administration and writing aspect of that decision, as well as supports for Indigenous people who are incarcerated, including restorative justice, for example, reintegration planning and connection to culture, as well as justice summits and forums coming up. In terms of some of the process of the strategy development, the MOU committed to make best efforts to develop the strategy within 2 years. This timeline was grounded in the acknowledgement that the strategy must be properly co-developed between First Nations and BC and reflect the solutions that First Nations have developed. Over the past 2 years, systematic work has been done by First Nations across BC, supported by the efforts and coordination of the First Nations Justice Council to develop the elements of the strategy. All of this work was done in partnership with BC and has included multiple venues and processes to ensure that First Nations and BC political leadership are aligned. The process of the development of the strategy has taken place in 3 phases. Phase 1 really highlights the focus on knowledge sharing, during which First Nations and BC political leadership, the Justice Council, justice system actors, and experts built shared understandings, knowledge, and perspectives about the challenges to be addressed and the approaches to strategies and solutions. Some of these have included the 10th Justice Summit that took place in May to June of 2018. That summit focused on Indigenous justice, gathering a cross-section of leaders and experts, and included a full day of Indigenous caucus. The 11th Justice Summit, held November 2nd and 3rd of last year, that summit built on the 10th Justice Summit with the goal of providing concrete recommendations on transforming Indigenous justice. The Gladue Knowledge Sharing Gathering took place October 3rd and 4th of last year. That gathering brought together leaders and experts to share, inform, and identify actions for the full implementation of Gladue in British Columbia. Followed by the Indigenous Justice Planning Session that took place on November 4th of last year. This is a facilitated dialogue between the First Nations Leadership Council, the First Nations Justice Council, and BC ministers to discuss the planning elements and development of that strategy. Phase 2 included intense First Nations engagement, during which First Nations provided guidance and direction on the elements of a strategy. The really big event that really started that in-depth engagement was, as mentioned before, the First Nations Provincial Justice Forum that took place in April of this year. This was a province-wide gathering of First Nations leaders to provide direction on the substance of the strategy. The forum included intensive small group sessions where all First Nations participants could provide direction and perspectives on the strategy. Followed by the regional justice forums that took place between June and July of this year. 4 regional forums were held in Nanaimo, Prince George, Vernon, and Chilliwack for First Nations communities and service providers to provide guidance and substance on the strategy, including sharing of specific perspectives and experiences. Dialogues at BCAFN, UBCIC, and First Nations Summit in 2018 and 2019. The Justice Council had dialogue regarding the elements of the strategy with the assembled leadership at multiple meetings of First Nations organizations, such as this meeting currently taking place. Phase 3, and this is the phase that we currently find ourselves in, the strategy drafting and testing, during which the Justice Summit will be providing updates such as this one on the work of our council at the Summit, BCAFN, and UBCIC.
Strategy been shared with you yet?
This also includes this meeting here, which is the second bullet, the First Nations Summit, which will be taking place in a couple of weeks, as well as the First Nations Leadership Caucus meeting held in October 2019. This will be a facilitated dialogue between the Leadership Council, the Justice Council, and BC ministers to discuss and implement, or discuss the draft and the implementation of the strategy. Another important aspect of our work we're currently undertaking is with respect to the Indigenous Justice Centres. The Justice Council is currently undertaking the hiring of a provincial director to oversee and design the implementation of the centres. As well, the First Nations Justice Council is currently ascertaining which communities will be selected to host the initial up to 3 justice centres. As well, once the host communities are identified, engagement sessions will be scheduled to identify their service needs. With respect to Gladue, the First Nations Justice Council is currently working with the province, Indigenous partners and stakeholders to develop further future state Gladue for the province based on the information gathered through prior reports and recommendations and the various phases of the First Nations Justice Strategy. So the next steps are the Justice Council will continue to work on its mandate through the jointly identified priority initiatives and will continue its collaboration with the province throughout the fall to co-develop the First Nations Justice Strategy. That's it.
Mike 5.
Yeah, thank you, Rosalie, Doug, Minister Eby. Really appreciate being here on the lands of the Musqueam people. You know, our people are really intermarried, so we have that close connection with the Musqueam here, and thank you for, you know, allowing us to be here. I think it's really important. Also, congratulate us youth on another term. I think it's your 3rd time uncontested, so that must be a really good sign. Stuart's also on our Kukikwelp Senate committee, so we do a lot of work together. The work that is being done by the Justice Council here is really significant. It's transformative. Our people rely on symbolism a lot. When we had our Justice Summit here last year, there was a big eagle roosting on the sunroof at the Musqueam Cultural Center here. And to me, that was a real sign, you know, that well, people were sharing their life experiences and how the justice system has let us down. And to me, it was a way that, you know, that big eagle would take all of those prayers and bring it to our Chicha Siam, our Creator, and, you know, help us. It's a sign that things are moving in the right direction. With our Indigenous Justice Strategy, we haven't released it yet, but it's going to be holistic, so that we heard that clearly at a lot of these sessions, that, you know, it has to be all-encompassing because everything is connected. And it's not just that linear thinking or having those streamlined like that. Our people look at things as everything is connected. And we strongly believe that that's what needs to happen to be able to develop our own Indigenous justice institutions and our own policies and our own laws. Our Indigenous laws have been here forever. And our elders and our ancestors will tell us that. So that's the direction that we're going, that we need balance and we need to recognize the family connections, and we know our roles, and prevention will be emphasized. And I really appreciate, working directly with the ministers, Eby and Farnworth, and being at the same table with them, having this government-to-government relationship, and to be able to make this strategy something that will be, that can't be undone, and it's going to be really transformative. And it's something that our people have been waiting for a long, long time. And I'm really glad that we're at this point now. We're able to, sit at the same table, draft this Indigenous justice strategy, and make a real positive change for our people. So I'm just thanking everybody at the table. We'll see you.
Thank you. Any questions or comments from the chiefs and delegates? Mike 18.
Good morning, Debbie Abbott, proxy for Boston Bar First Nation in Tlakapan. I just wanted to share some good work that the Shememit Project is doing on behalf of our communities. We are establishing a social justice mediation training December 11th to the 15th. It'll probably be in Vancouver. The cost will probably be around $2,000, and there's only space available for 24. And for the social justice mediation, it was developed in the United States and challenges the idea that mediation or alternative dispute resolution is neutral. Research shows that when people of color enter mediation, they get less and pay more than others. Social justice mediation tries to find ways to try to level the playing field and to address the unspoken biases that occur in a mediation or adjudication processes. We believe it can be helpful in starting to equal things for Indigenous peoples by calling into question how neutral mediation is. If you may be interested in attending and want us to send you the registration form information when it is available, please sign up. And I'll send this around. Cookstem.
Cookstem, Councillor, Mike 12. Mike 11.
Uklasish Sicha, Istakshit Tlaokwit, Terry Dorward, proxy for Tlaokwit First Nations. I'd like to thank the Musqueam people for allowing us to do this important business today. And it's good to see David Eby. It wasn't too long ago I was losing money at poker with you.
Sorry about that.
My question, and congratulations to Stuart Phillip. I was there in '98 when you were first elected, and watched this organization grow since then, and you've always been a big supporter of Indigenous title and rights. Back then, it was part of the ragtag Native youth movement. My question is to David, in terms of, I know years ago when you were working with the BC Civil Liberties, working on sobering centers in remote areas. As you might recall, we lost a member in Tofino in city cells because the jails weren't equipped with the proper health. They basically neglected our citizen, Tlaokwit citizen, and he had died. So I'm just wondering, has there been any movement in terms of sober centers? Thank you.
Tlako. Any other questions or comments? Seeing none, we'll go to Mike 5.
Thanks very much, and thanks for the reminder about the important work that was done. The Frank Paul Public Inquiry, UBCIC, was there obviously under the leadership of your re-elected Grand Chief, and it was a really important public inquiry that one of the key recommendations, among other important recommendations, was the establishment of sobering centers. Initiatives like sobering centers and getting people out of the justice system who shouldn't be there. I mean, someone who is overly intoxicated shouldn't be in jail. They should be in a health setting. I think that the focus of government has really been on the overdose crisis with fentanyl in the short term because of the numbers of deaths, almost 1,300 deaths a year resulting from fentanyl, and identifying ways to deal with overdoses related to that drug rather than alcohol. But that is not to say that government or I have lost track of that important recommendation. There's a new Ministry of Mental Health and Addiction. They have been working with the Centre for Excellence in Addiction and Mental Health in British Columbia on treatment guidelines for people with alcohol addiction, and government has been providing support for that, including making more available medications that assist people that are dealing with alcohol addiction. Also our housing projects, which focus on modular housing and people who are chronically homeless, like Frank Paul was, are projects that welcome people in whatever stage of the addiction they might be facing, with supports for them to live inside. I think that if Frank had had a place to live, he might not have needed a sobering center. And so on one hand, I can tell you that to my knowledge, the Ministry of Public Safety, I don't know if they've been doing work on this, but on the other hand, we've been doing a lot of work that makes a lot of difference for people who are in the situation that Frank Paul was in. And I think that we're on the right track on that. I would welcome any feedback from the First Nations Justice Council that we're working with on incorporating initiatives in communities where that's particularly acute need as part of our Indigenous justice strategy, if that's an Indigenous justice priority. And if not, government will continue to work on it as part of a broader initiative around addiction and mental health. With the focus, though, as I've said, really on the fentanyl crisis right now. Thanks for asking.
Mike 11.
Tip Cookby Razan Casimir, Rins West at the Comlifts to Schwatmuck. I'm very honored to be here and to be sitting around this here table of the leadership that is here, and also to acknowledge the unceded lands of the Musqueam. So I just wanted to ask and address a few things in regards to the Day Scholars. So yesterday was Orange Shirt Day, and for our community, this day is very important. You know, it's just like Remembrance Day, wearing that orange shirt. It's about being as equally respective and respectful, like we acknowledge and respect Remembrance Day. So it's a day to remember. It's more than just that for us. And it's about, you know, remembering the children who survived in the residential school and remembering those who did not. And so this was very huge for our community yesterday. We had hundreds and hundreds of people that came to our MSG yesterday, who came and participated, who came and shared their stories and that history. And for, you know, a lot of participation to, you know, for the younger generations to come out and learn. So this year also brings on the question in regards to the Day Scholars. So when we're looking at all the different dialogues at the different tables that we've had with the various ministers at every single level, whether it's the provincial, whether it's the federal, we've even had dialogue with Justin Trudeau, and, you know, asking him questions like if he was going to follow through on, you know, a fair settlement in regards to the Day Scholars. And, you know, in regards to the Truth and Reconciliation calls to action, and looking at, you know, those that were left behind. And those are the Day Scholars. And so this year is something that's not new, and I know that you've probably heard about it at different levels, Minister Eby. And so I just wanted to follow up on that and find out, you know, what are going to be the next steps? And, you know, I know you probably can't answer all that, but it's messages that I want you to take back with you and looking for resolve on behalf of our people who attended and those that were forgotten, left behind. For me, this is very important for our community and for the communities that we also represent, and for those that are on there. I think there's 118 First Nations who are also signed up with that as well, and that we represent. And, you know, there's TTS, Sea Shout, and James Bay. We're all, you know, advocating on behalf of, and we want to see some follow through. And so what are the next steps in regards to the reconciliation? The McLean case has been resolved and is not completely resolved, but it's still definitely made a lot of traction. I would like to see some resolve for our communities who've been left behind.
Cookstem Cookby, response and concluding remarks from the Minister first. Mike 5.
Thanks very much. I don't know what work I imagine it's centered in the Ministry of Scott Fraser, our minister, who's been working on reconciliation efforts, but obviously all of our ministries have key reconciliation roles. I will find out what work specifically on Day Scholars is underway in terms of reconciliation. I want to thank you for your work on Orange Shirt Day. My son went to school in an orange shirt. And all of his colleagues at school, there was a reminder sent out to all the parents to wear orange shirts to school. And as part of their, it's kind of funny as someone who grew up in a school that didn't even really acknowledge Indigenous people in the teaching that I had in grade school and high school, to see my son. He came home and he was talking about how he was in a circle of courage and he learned about the Musqueam people and all this. He's in kindergarten. And how that work of reconciliation is happening at the schools is really inspirational and touching, and it was treated like Remembrance Day. It was a day when all the parents were reminded to participate. So thank you for your work in raising that awareness, because it's the next generation that's going to really help us get to where we need to get. And so thanks for that. I will ask staff to make sure that we follow up with you about the Day Scholar issue specifically and what the province is doing on that. Thanks for the reminder.
Thank you, Minister. And just pointing out to the Chiefs Council that the eagle that Boyd mentioned in his update is actually on the screen right now. Concluding remarks from a Justice Council rep. Mike 4.
Thank you. Thank you so much to the Union BC Indian Chiefs for the opportunity to present this work where we're at. We're at a turning point, a critical moment in what is, as Boyd said, this is a transformative opportunity for our people to make a significant difference in the criminal justice system and to start to find ways and to build clear pathways to support Indigenous peoples in creating their own criminal justice system, and for us to do the work that's necessary to reform and to change the existing criminal justice system to ensure that it's less punishing and it functions in a way that's respectful of our people. The Orange Shirt Day yesterday for me really brought home the point. I think about all of the survivors, for those that perished in the residential school system, as the National Center released that information yesterday. For me, it was a sorrowful day. It hurt to think about those issues. And for me, it creates more momentum for us to grapple with the ongoing reality in our society that more than 60% of the children in care in BC are our children. Just an astonishing crisis that has to be addressed. And upwards of 30% of the people incarcerated in this province are our people. So there's some unbelievable crises that are happening now today. And so for me, when I think about where we've been, the strength and the resilience that our people have shown through that experience of cultural genocide and genocide, that what it does for us is just brings into the sharpest possible focus how important the work is that we do in this room, how important the work is that we do together to change the lived reality of our people. That's for me the test of every day that I've spent. Is the work that I'm doing going to make a difference in the lives of our people or not? This work, I think it has that significant opportunity to do so. It's because of the strength of your leadership and the engagement that you've shown with us and the direction you've given to us over the past couple of years that we're at a place where we're going to make a real difference in the lives of our people. So for that, I have the greatest respect and gratitude. So thank you very much.
Thank you to the panel. We move directly into inviting forward Minister Melanie Mark for an update on the Ministry of Advanced Education and Skills Training. So just as we're transitioning, if you haven't noticed yet, your binders look a little bit different. Your entire binder is marked with page numbers. And at the start of each section, there's an index and a breakdown of what's in each of the sections to make it easier for you to follow along with any of the presentations. So rather than looking for things, it's right in front of you. Microphone 5. Either, sure. Mic 4.
Mic 4. Someone left their cell phone.
I think it's Rosalie's.
Rosalie?
Yeah, she's over here.
Good morning, everyone. Simgiget, Sigidamanak, Gibidwiltsuk. My Niska name is Lahaikwiskak. I'm from Lakulzap. I'm Niskat, Old Town, Hazelton, Gitsan. My dad's from the Red River, Ishnabe, Cree and Ojibwe. I want to acknowledge the beautiful territory of the Musqueam today and to thank the executive for their leadership. I requested to sit side by side Grand Chief Stuart Phillip. It's my honor to sit beside you at this table. And it's just an honor to be here with all of you today to give a bit of an update. I got elected in 2016 as an MLA for Vancouver Mount Pleasant. And in 2017, Premier John Horgan appointed me as the Minister for Advanced Education, Skills and Training. I'm sure you've already heard this, but there has never been a First Nations woman that has had a seat in the BC legislature or at the cabinet table, and I want to thank all of you who have helped me on my journey so far. I have a few updates about what I've been responsible for as the Minister for Advanced Education, Skills and Training. I'm responsible for the 25 public post-secondaries in the province, the Industry Training Authority, the Workforce Development Agreement, and TRC, as Minister Eby pointed out, was a key pillar of the work that Premier John Horgan has mandated us to do. I will be asking my staff, Diego's going to hand out some fact sheets. One is about the tuition waiver program, another is about Indigenous training and skills opportunities that we've been providing across the province, and another is just a general budget update. But I guess where I want to frame my remarks, as Minister, the most exciting part of my job is getting out to community and having a chance to visit with community to talk about what the community needs are. First Nations Leadership Gathering is a great gathering, but it's speed dating, it's 15 minutes, and you really can't get to the heart of some of the systemic issues that need to change. When I had a chance to visit a house-it, one of the things that I heard was for the first time there's internet in the community and the difference that broadband and internet activity can bring to communities when you connect community. When I went to Skidegate, I had learned about an innovative program that was being brought to the elementary school to bring virtual reality to the classroom, and you can't do that without the internet. I've had a chance over the last 2 years to follow up on some very important work with FNESC, First Nations Education Steering Committee. We've been paddling together. We've had some hard conversations, meaningful conversations. As Grand Chief Stuart Phillip has said in the past, reconciliation isn't for wimps. But I have to honor my mentor who's here, Mary-Ellen Turpel-Lafond, who I worked with for 8 years, advocating for the most vulnerable kids in care. And it's the inaction of what happened for our kids in care that got me into politics. But getting into politics is hard. It is hard to be the only one at the table. And I can't undo the last 140 years of colonization. But to the remarks of Orange Shirt Day and what that means, my grandmother went to St. Michael's. My dad's parents went to Brandon and Elk Lake. My Gitxsan grandfather hid from Indian agents. I became an advocate because my mom had a broken heart in the downtown east side. And while she was down there, I was advocating so that my brothers didn't eat off the floor like dogs because of the way they were being treated in foster care. So I signed up for this job to make change. And we have to turn things around. And like you, I won't speak for you, but the system has done nothing but fail me. But having a chance to have a seat at the table to turn things around for my kids. Yesterday, my 8-year-old daughter, Michaela, addressed her entire school about what it was like for my grandparents, for my grandmother to go to residential school in Alert Bay and come home to her parents that were dead. That no one had the decency to tell her that her family was gone. I get the injustices, but only by paddling together, which is not a slogan. Reconciliation isn't for wimps, but to make the hard, heavy lifting work, we got to paddle together. We have to lift each other up. And I look to Joan in this room. Joan is stepping up in a world right now. Joan Phillip is stepping up in a world that we didn't create, to make change to the rules that we didn't write, to turn things around for our community so that we are thriving. One of the best things that I did 6 weeks on the job with Premier John Horgan and our NDP government, we made it tuition-free for former youth in care. And that was one of the best days of my life. Because in my heart, I believe that if you give people a chance, they will step up and they will rise to the occasion. And to this day, there's almost 1,000 kids that are benefiting from that program. Is it enough? Of course we have to do more. But I got into politics because Mary-Ellen Turpel-Lafon challenged Stephanie Carew and the former BC Liberal government to fight for kids in care. And all we heard about was balanced budgets, AAA credit ratings, and balanced budgets. Our NDP government has a balanced budget. We're just making choices to invest in people and not leave them behind. I want to acknowledge Diego, who's with me. Diego is my executive support staff. He's also a former youth in care. And I'm a former youth in care. And when you have a seat at the table, I think it makes a difference. Because we've seen a world that other people have only read about. So I have a lot to say that I'm proud of. We have Indigenous governance in all 25 public post-secondary institutions. That was a call to action in 2012. And again, through the work of working with FINESC. But being the only Indigenous person at the table of colonial institutions on our traditional territories, it's going to take some heavy lifting. We need to make sure that our students are supported to become the doctors, to get their masters. And the thing is, our students are thriving in college and university, but they need support. Mary Ellen probably has a quote or two as well about reconciliation not being for wimps. But I'm very proud that we have Indigenous representation at the table, and there's more to do to support that continued vision, to have a voice to advocate for our students. I want to give a shout out to the First Nations Tech Council. They also have a mandate from your resolutions along with Finesk and Ihala. They're advocating fiercely to bring that connectivity to your, and I always joke because when I say connectivity, I come from the projects of East Vancouver, so I'm not sure exactly what we're talking about. But to bring bandwidth activity into our backyards is going to give us that access to education in a way that hasn't been there before. My colleague David Eby talked about UNDRIP legislation. I do serve as one of the members in cabinet for the Committee on Reconciliation. I also sit on the Premier's Priorities and Accountability table. It's an honor to serve on those tables, and the part that I get to play, and this is where I believe I bring my culture to the table. From being from the Eagle clan, I get to see things from high above and pull the pieces together. And one of the things that I'm really, really trying to do is break down some of the silos. There's so much left hand, right hand, people aren't on the same page, and those divide and conquer days have to be behind us. And the only way we can get there is bringing people to the table and being transparent. So I just want to put that also on the table that Finesk is working with us, because one of the areas that I see in my ministry is around skills and training. I meet tons of people that are trying to find people to bring onto the job site, but they don't know how to reach out to First Nations leaders. There isn't a policy framework or a protocol framework. So I often hear we're trying to find the people, but they don't know how to invite themselves to community. I recognize that I'm standing 5 minutes between your lunch, so I'm going to pause for a moment and share a little bit of fun with you. We put a video together. It's 3 minutes. It's 24 things that we did in 24 months as an NDP government in my portfolio. I hope you enjoy. Tuxieism. $450 million for 5,000 One more. Thank you for your time. I guess I want to close on two remarks. Grand Chief Stuart Phillip often talks about his grandchildren, and I always forget, but I think it's 18. 15. Okay, well, I just gave him 3 more. Maybe triplets are on their way. I don't have grandchildren, but I have 2 daughters. And when I think about reconciliation, I want them to live a life free of violence. And I am extremely optimistic that we can turn things around. I've shared with people, and people say, well, we don't have to hear about your story. But I think it is important to tell our stories and celebrate our determination and our resilience. My mom's almost 14 years clean and sober. She sobered up on my 30th birthday. You have to be there for your family when they're ready and not give up on them. So my values are to look at and honor my grandparents, to honor my mom and the best life that she could give me, to give the best life to my daughters, but to make decisions and an impact that are going to benefit our grandchildren. So when I go to work, like you, I don't get to see my family. I'm on the road a lot. So when I'm making decisions, it's not to ruin communities. It's to leave permanent marks that are going to benefit our communities. And on that note, the tuition waiver, when I say it was the best day of my life, it was the right thing to do. And that's why it was easy. But it was those rights of kids in care that we need to be fighting for. Like Doug White mentioned earlier, 60% of those kids in care need our voice. And they need us to believe in them, that they can become amazing things if they have the support. So I want to thank everyone for the time today. Tuksiyasm for your leadership in your community. Hawa.
Thank you, Minister. We do have time for 1 or 2 questions or comments before we break for lunch. Should there be any?
Right on time.
Mike 15.
Thank you. My name is Michelle Edwards. I'm the chief of the Cayuga Creek Indian Band, Statliam Nation. Very thankful to be here, to be able to speak in front of everybody. Congratulations on being who you are and where you've gotten yourself. When it comes to trades training, though, and being impacted, all of us are impacted by industry. And I think that's really important that we all start getting involved in that, because infrastructure right now needs to be upgraded. And I think that's where we need to start coming in and being full participants in upgrading all facilities that are in our backyards, and really focusing on the education. In Lillooet, it's pretty much 70% of the population is Indigenous. And I think we should be encouraging our children to become teachers because they can go back home and they can have careers, and they can stay at home and they can have the independence and talk about who we are and start closing that gap a little bit on racism. I don't think we'll ever get, but that's a start there. So I think in your position to really go back to the governments that you sit with and talk about how we participate in updating all of the infrastructure, because that's billions of dollars of industry that needs it. And if you can do that and just start getting everybody on board with updating it at least, because I always ask people, why do you have an asset and not look after it? That just doesn't make any sense. And if that's the Shamat way, then we need to change how they're doing that. So I'm hoping that's something that you can do because we're ready to do it. We have to do it because most infrastructure is ruining our ecosystems. And I know that in the Statliam for sure. BC Hydro is a huge scar in our backyard. So Cookstem.
Cookstem Cookby, Mike 10.
Weil ko khoirap mimel drans quest skeram kukpi. Kukstakuk and Masquim. That the cirque. First of all, I went into trades in 1992, 93, 94, 95. Unfortunately, there's still a lot of discrimination out there. Top of my class in heavy-duty mechanics. I had 3 chances at 3 apprenticeship programs to get my red seal. Every one of those interviews, I was turned away at the door because of my skin color. This is happening throughout this province, and we need to do something about it. And Melanie, I think you have it in your power to do something, so that as First Nations people, we can start sending our students to First Nations communities to get their red seals approved, to get their apprenticeships done. That way they don't have to deal with the discrimination of being First Nations. Not only that, even though I did finish top of my class, there was a lot of discrimination in the classroom. I mean, I was being molded to be a chief, but I had white Semat people calling me chief. They were calling me chief before I was even elected. And this was soon after being taught about ethics in the workplace. And still this was happening. The only way I could end that was I called them out on it. Told him, you call me chief one more time, we're going to take this outside, out of the classroom. And I said it right in front of the whole class. Even the instructor was there. And he didn't try to stop us at all. So we need to find a way as First Nations people so that we can start getting the apprenticeship programs in our communities. To start working together on the housing situation. Get the electricians out there, and you know, there's a lot of different ways we can go about doing this as leadership. We need to start looking at how we can create something better for the next generation. And how are we going to go about doing that? DIA, ISC, INAC, whatever you want to call them nowadays, they're trying to hand over the housing authority to First Nations people. If that's the case, let's take it and let's run with it and start looking at educating our people and getting the red seals and everything improved through our First Nations housing authority, rather than depending on Joe Blow that sees me as a tax write-off. And it's a frustrating thing when you see that in the Semat's eyes as soon as you start walking into to get an interview. It's not a nice feeling. And that was one of the reasons why I got into politics, was to put a stop to that. And I really hope that as a leadership around this table that we can start to do something about that and to create something for our students. Thank you. Kukshem.
Kukshem Cookby. We're after 12 ministers, so brief responses and concluding remarks. Mike 4.
Thank you both for your comments. I have a deep passion for the trades, so I never learned about red seals until I became the minister, and so it's been a steep learning curve, but I do live in a world where there's a lot of discrimination. I meet people that say, I have 2 kids, one's smart and going to university, and the other one's getting their red seal. We need to change that narrative, because I believe the self-determination is in having our communities trained up to be the millwrights, the electricians, the carpenters, the plumbers, instead of bringing in the outside to fix some of those in our communities. I would share that, and I'm sorry that you faced the discrimination. I've heard a lot of that over the last 2 years. I'll give you 2 tools. The Industry Training Authority has a mandate letter from me that says we need to turn things around, so that's your tool. You just point to the Industry Training Authority's letter from me as minister to say you have to be working with Indigenous communities. In this fact sheet that I shared with you, it's got the phone number It's not good enough to point you to a website. It has the phone number for the Industry Training Authority. They have new advisors working with community to make sure we have those apprenticeship placements. Those are some of the steps. The piece around community benefit agreements, Premier John Horgan mandated community benefit agreements. Essentially, if we're going to build bridges, then the people should benefit. And if you're an apprentice, the only way you learn about building a bridge is on the job. The only way you learn about building a hospital or a school is on the job. You don't get the hours without the hands-on experience. And we're taking political punches for that. So it'd be really helpful to have the chiefs acknowledge that community benefit agreements are exactly that. We have ratios that will ensure that Indigenous, women, and underrepresented groups have a job on those community projects. And the very last thing I'll ask, and this is a call to action, we want to reinstate or explore reinstating compulsory trades. The BC Liberals dismantled it when they formed government. And when you dismantle a system that says you should or must or have to have a red seal, then you take away the standard. And we want to bring back that standard to say you have to have a red seal if you want to work in these industries, and you can't get a red seal without having the apprenticeship. So thank you for your questions. I'm very, very passionate about the trades and moving the dial. Hawa.
How long are you here?
I'm going to stay for a little bit, and then I'm going to run.
Okay, I just seen a late hand up. We don't have time to go to you because we're after lunch, but the minister is here for a bit. Yeah. So thank you, Minister.
Thank you.
So inviting the elder forward to bless the table on her way up, just a quick housekeeping thing. Everybody's aware of the condition that David Dennis is in. The union is supporting by providing a UBCIC jacket available for you for $125 or a hat. You pre-order the hat outside of registration, or sorry, the jacket outside of registration, or there's hats there with proceeds going to David because he's basically paying for his medical costs out of pocket. And secondly, in support of it, out in the registration, you see the picture up in a stand called Bonaparte Occupation. That picture and a $100 gas card is being raffled off by Elaine Alec. If you don't know Elaine, can you wave, please, over here? $2 a ticket or 3 for $5. Those proceeds going towards David Dennis's medical costs as well. And a reminder that we do have the honoring celebration at 12:45, so a little bit of an abbreviated lunch. Some of you like to come forward and have lunch up at the front here. I ask you not to do that because the Charlie family will be occupying these empty seats up here. So we'll reconvene at 12:45. Elder?
So I think you had a very productive morning, and I want to thank Melanie Mark for her enthusiastic remarks. So make us truly grateful for what we're about to receive. Bless the food and the hands who prepared it. Amen.
Where did she go to school? Yeah. 3. 3. Well, they were going like this.